So what I want to look at first is your warm-up questions. And with question 4, what did let me put it this way, the ERA amendment, what did it simply look to do? I want to see like how controversial or how kind of disruptive it was. Do you remember anything about the language, what it was essentially suggesting? And you can dip back into the article if you need to. Do you remember? Go ahead.
It said like equal rights between the sexes, and so people thought it was controversial because they thought like, oh, if I'm a man, I can just go into the women's bathroom now.
Yeah, so it is kind of funny how the language is fairly innocuous. It's simply saying that we're going to guarantee equal treatment under the law, regardless of sex. That it's making sex discrimination illegal. As you read it. Equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. Now, what amendment could you argue already has this language? The 14th, no state shall. And you can talk about privileges and immunities. You can talk about equal protection. You could talk about due process. And if I'm saying you can't infringe on those things, those are guarantees regardless of, age, race, religion. But we wanted something more unique for women, in part because they arguably then and still do face more kind of unique forms of discrimination. What was the slogan that they eventually adopted to try to like bring that point clear to people?
59 cents.
Yeah, what was that meaning? What do we mean?
59 cents to the man's dollar.
So if you look at kind of people doing the same job, women made 59 cents to the dollar for doing the same kind of job. And we can still look at, is there equity in pay? The article in the end kind of talks about strides women made. And I feel like that's a little patronizing, that particular section where it says, hey, there's women doctors and there's, but I do think that, when you begin to look at women in leadership and women in certain professions, it is good to see is there a balance there, all right? So that's another way that you can kind of look at this, maybe a unique need to have some unique protection. Some of the problem, though, is, well, how are you going to, okay, so let's say an employer does discriminate in terms of pay. Will this allow you any legal remedy? And that kind of helped unravel it. Who else tried to, speaking of factions, what else kind of unraveled it? Do you remember, Paul?
Phyllis Schlafly.
Yeah, what did she do?
She was the attorney for the opposition to it that basically said that she was anti-feminist.
Yeah, so she kind of, it's interesting. It's a conservative women's group that basically said, this is too liberal. This is, against kind of our conservative values that, on some level they introduced the fear that if you raise women's pay, then you're going to lower men's pay, that you'll, adversely affect the economy. Also kind of, it's not our place almost was some of the idea. How about on the other end of the spectrum? So I've got kind of conservative women's groups working against them. Were there others? Remember there was the kind of the more liberal faction that said this doesn't go far enough, and they kind of in some ways mocked the middle class moms that were kind of a bedrock group of the group. So
what was the national organization for women?
Yeah, so you've got initially remember for Betty Friedan and the Feminine Mystique. Remember how many often you kind of read that? Well, she's a very important figure in terms of the women's movement. And so she's kind of the center of it, and then they lose, it because of the kind of the radical groups. So how many states did we need? How many states do you need to get an amendment passed in terms of state ratification? What does 3/4 look like? Do you remember? 38. How close did they get? 35. Why couldn't they get to 38? What happened before they were able to get to 38? Anybody remember? What happened before they got to 38? Well, let me put it this way. When was the amendment kind of first proposed? We're not talking when we started the ratification process, but did you pick up on when it was first proposed? 1923, right? So they finally begin to try to do state ratification when? You're looking at that same area. 1972, all right? So could they do this process indefinitely? What happened before they got to the 38?
They reached the 7-year limit.
They ran out of time. Yeah, they reached a 7-year limit. They voted themselves an extension, but by then the political momentum had turned. So they had a consensus. Do you remember there was, if you polled the American public, where were they on the ERA amendment?
Supported it.
Yeah, do you remember anybody remember the percentage? I mean, it wasn't overwhelming, but it certainly was a majority. 54%. So they had a majority, but what happens is because this is such a long, difficult, drawn-out process, holding that majority together, holding that momentum together kind of eroded, and you lost it. So long way to go to kind of show you the difficulty again, but there's a way to do it more concisely, obviously, but that's a great way to show that the amendment process is ridiculously difficult, and again, rightly so. You need overwhelming consensus. The other way, again, is 27 amendments out of how many proposed? 10,000. So that's another way to show that it's really difficult, and again, why we prefer the informal methods of amendment. If you are going to do examples of informal amending, you want to talk about a branch acting unilaterally and essentially redefining the Constitution without changing the language, right? So if we're going to do it with the legislative branch, they have to do it via the judicial branch. But remember, what power do they claim that isn't there? And they get this huge array of kind of unspecified powers without changing the language of the Constitution. What power do they claim that isn't there in specific language? It's there in vague language. The judicial branch. No, excuse me, the legislative. Oh, yeah, there we go. Legislative branch. This is all on film. Yeah, so what are the powers that go with that specifically? I've got delegated powers in the... go one more deep. The implied. So from the necessary and proper clause, they claim implied powers via what court case? McCulloch versus Maryland, right? And they also will look, when we look at the judicial branch, give an expanded definition to the supremacy clause as well, all right? So you follow, that's the best example of the legislative branch, basically using vague language to claim expanded powers without changing the language of the Constitution. When I do the executive branch, what's an easy, again, kind of classic example where there's vague language that lets the president do something, and Congress defers. There's your kind of hint. What do you got? Commander-in-Chief. What does the president use that power to do? That kind of trumps congressional power. Makes war. Congress does what? Declares war. So the president has used that vague term to kind of act unilaterally and claim expanded powers, again, without changing the language of the Constitution. And again, Congress defers because they kind of want the president to have that authority. The nature of war kind of demands often unilateral action that can be covert if necessary, and it's hard to be covert with 535 members. And the president's more accountable that way, and they kind of want the accountability there. All right, so that's one. What else do you remember the other phrase that the president can use? And then they have all these kind of interesting ways in which they either they kind of claim legislative power. Let me put it that way. Yeah, so that's the example. What's the phrase that they're using to kind of get away with executive orders? Faithfully execute. So faithfully execute is subjective, and therefore they can kind of decide that I need more power. I need to direct my agencies more specifically to do something via an executive order. Who's got a classic example of an executive order?
9-0.
Oh, you get the number. Very good.
I think it's 6-6.
Yeah. What is that?
Japanese internment.
Japanese internment. One's the classic examples. I'm waging war, and I'm trying to faithfully execute that declaration of war, and that means that I've got to keep the country safe domestically. And so I'm going to authorize Japanese internment camps. It somehow derives from that faithfully execute, or just simply the idea that they have executive power and they can tell the agencies what to do, right? Give me another classic example. Emancipation Proclamation, right? So again, you can either derive it from faithfully execute, or if you don't have necessarily a law that's there, just the idea that I'm chief executive and I'm supposed to execute. I've got signing statement. Excuse me, I just gave one away. I've got executive orders. What's the one I just slipped on? Then you can explain it to me. What is it?
The signing statement is when the president's signing into the law and he basically says what he's how he's interpreting.
Yeah, and how do they get away with that? What does he usually say supersedes the law? That I know the law says this, but I'm not going to necessarily interpret it that way because what does the law, infringe upon?
His ability to faithfully execute.
Yeah, the ability to faithfully execute law. What other responsibilities do they have? I've got to faithfully execute the law and uphold the Constitution. If you, again, didn't see it, remember the idea of, executive power. If it infringes upon my executive power, if it infringes upon my ability to act as commander-in-chief, they'll use that as a way of saying that those responsibilities trump this law. Okay? Give me another way that the executive can kind of, robustly kind of put a law into effect, or anemically put the law into effect.
Not funding a law.
Yeah, so again, remember, they submit the budget, and the budget will fund departments and agencies, and department and agencies are helping to execute law, to carry it out. So I can kind of do it that way as well. And again, I can get away with it because I'm faithfully executing. And again, no language changes, right? So I see a number of ways in which, again, the executive branch is able to essentially claim unspecified powers by acting unilaterally without any objection from the other branches. It becomes, a guaranteed power, and no language in the Constitution changes. Now, the last way we look at it is the courts. And what we want to talk about is essentially, again, it's governmental action, but it has a unique name. It's judicial review. And the case in which they claim it is Marbury versus Madison. Remember, this is the case where it's over the midnight appointments. That's your access phrase. That's how you'll kind of trigger everything that you need. So Jefferson, the Democratic Republican, is coming into office. Adams, the Federalist, is outgoing. These guys used to be friends, now they're frenemies. There's maybe, they die on the same day, their last thoughts are of each other. It's a very intense kind of, friendship, and then they drift apart over politics. But I think there is still kind of a mutual respect, but at this point they just, can't stand each other and what the other one stands for politically. So Adams, who's rather spiteful, he's a curmudgeon, packs the judiciary with a number of last-minute appointments. It comes in under the Judiciary Act. The Judiciary Act creates all these new federal appointments. And Adams, knowing that justices serve for life, tries to cement some kind of legacy for the Federalist Party by filling all these commissions in a very hasty kind of way, with Federalists. And Jefferson comes in and rightly says the Federalists have retired into the judiciary, meaning they're setting up camp and they'll be there for life. The only way he can strike back is there's a number of commissions left on his desk, or in the incoming Secretary of State's James Madison's desk, that have been signed, sealed, but not delivered. Literally, that's how hasty things are. John Marshall, the outgoing Secretary of State, who he himself is a midnight appointment and going on to become Chief Justice, didn't get it all done. And so the incoming Secretary of State asked Jefferson, what should I do? And Jefferson says, don't file them. Within those unfiled commissions is a guy named Marbury, who is a appointee to become Justice of the Peace in Washington, D.C., and he wants his job. And so he sues. What he gets to do, because of the Judiciary Act, is go right to the Supreme Court. Because what the Judiciary Act does, in addition to creating these new appointments, is say that the Supreme Court, this is the language you need, has original jurisdiction over cases of writs of mandamus. That takes some unraveling. All right, so a writ of mandamus, you hear the word writ, and mandamus means mandatory. When there is something that the government has to do as specified by law, they have to do it. The government is mandated to kind of meet its legal obligations. And if there is a question as to whether or not the government is meeting its legal obligations, according to the Judiciary Act, the Supreme Court looks at it. It's given original jurisdiction. It's given the right to look at those kind of cases first. There's a law that says the government is supposed to be doing something. They're not doing it. Do we have a right to compel? In those kind of cases, the Supreme Court was given, oddly enough, original jurisdiction. Why is that odd? What kind of court do we know the Supreme Court is? Is it a case that sees things first? What kind of case, what kind of court is it? What do you call it when you're seeing it second or third? It's an appeals court. So this is the legal window that John Marshall, who is, again, if you're going to know anything, Federalist 10. If you're going to know any quote, Federalist 51. If you're going to know any president, Washington and FDR. If you're going to know any Supreme Court justice, it's Marshall. He is the one that makes the court what it is and has some of the most important, impactful decisions. So Marshall takes this legal window and does the most brilliant legal maneuvering through it. What he does is he kind of makes a ruling that one smacks Jefferson, across the face. Basically, what he should do is go right to the decision of, we don't have the right to look at this case. But he decides to kind of wade in and say, Jefferson, you've overstepped. That, there is, for every right, there is a legal remedy. And in this case, there was a legal right. There is a legal right to receive a commission that had been lawfully executed. And so Marbury is deserving of his job, and he is deserving of a legal remedy. And then they pause and they say, just not here. Just not here. You're in the wrong court. You're in the wrong court because we're not a court of original jurisdiction. We're an appeals court. So feel free to file elsewhere. So what they've done is they've kind of taken a jab at Jefferson, but they haven't openly challenged him. If they had said, give Marbury his job, what would have Jefferson said? No. They would have said, Marshall has made this decision, now let him enforce it, right? These aren't, 9 guys in robes. Jefferson would not have enforced it, and the court would have looked, weak. It would have never been an institution of equal standing because there would have been nothing they could do about it. So they only go that far. But what they do is they claim power again by giving up power. What they gave up was original jurisdiction. Kind of a meaningless power in this case. Those cases will eventually get to them. What they claim is judicial review, the ability to look at acts of government and strike them down. But if they had taken a power away from Jefferson, would it have worked? If they had taken a power away from Congress, would it have worked? What they did is they took away a power that Congress gave them. And then by inaction, there's nothing anybody can do to challenge it. Right? So that's the legal window that he goes through, and it is brilliant. They claim the power of judicial review by taking a power away from themselves. And then they sit on it. They don't use it for a while. They're smart. When they do begin using it, they use it against the states. And it won't be until they are kind of a co-equal institution do they begin to use it to strike down the other branches. actions by the other branches. So I can't tell you how just amazing that case is. Now, and that in part is what the video will go over. So once again, if I'm summarizing, you see again the court continually, with the power of judicial review, changes the meaning of the Constitution and expands its powers without changing language. Informal is easier. It's a unilateral. I just move unilaterally. And as long as the other branches don't oppose, meaning has changed. Just as kind of other classic examples of where they use judicial review and they do this. They change the meaning of the Constitution unilaterally, and there's no objection, and therefore we have an updated Constitution. You could plug in McCulloch versus Maryland there as well. And then yesterday I went through in a rush Gibbons versus Ogden, only because, my gosh, is it one of the, Marbury versus Madison, McCulloch versus Maryland, Gibbons versus Ogden. If I'm going to kind of put things in a hierarchy. I said Marbury first, right? I think I have that as number one. So I should have you do, like Mr. Franco did the presidents, you line them up. We'll do that with Supreme Court cases, and you can decide where Roe v. Wade goes versus, Heart of Atlanta, Brown v. Board. Would that be fun? Should we do that with court cases? Gibbons versus Ogden. We talked about there's two rival steamship companies. One has a federal exclusive monopoly. One has a state exclusive monopoly. We have exclusive monopolies because you're ferrying people and you want that regulated so people don't die. Kady's not here, but she was driving the raft, remember? So we want to, regulate this. The question is, I can't have two monopolies. That, by definition, doesn't work. So which level of government has the right to issue an exclusive monopoly? Where do you think you'd normally go? What clause would you normally go in to say, okay, I've got a federal monopoly, I've got a state monopoly, who has the right to have the exclusive monopoly? Supremacy clause, but they don't go there. They go to the commerce clause. And this, man, does this open up a whole toolbox of powers. Because what they say is the federal government has the right to regulate interstate commerce. And so because of that clause, the federal government's monopoly supersedes the state one. What's interesting is that commerce, you would think of as the manufacture, distribution, and sale of goods. But this is the distribution, the transportation of people. People are commerce, or at least the movement of people are commerce. And therefore, everything is commerce. If I can make something tangentially relate to economics, if I can kind of see some sort of economic exchange, if what's happening has some sort of economic impact between two states, I can regulate it on the federal level. School. Does this relate to interstate commerce? I'm educating you. You're getting ideas. I may have gotten those ideas from somewhere else, a textbook that came from Texas. You eventually are going to enter into the workforce. You might go elsewhere for those jobs. Some of these classroom materials may have come from somewhere else. I think this came from overseas. This is interstate commerce. And because this is interstate commerce, I can come in and I can regulate to make sure that we're not discriminating. According to gender, according to race, I could regulate the curriculum, arguably. So that's just one example of all of a sudden the federal government, because of the Commerce Clause, getting to regulate things. A lot of the civil rights movement was because of the Commerce Clause, right? And arguably, there is no limit to it. Can you somehow make an argument that everything is tangentially related to interstate commerce? A mom and pop business, local Pingree Insurance, do they get their paper from somewhere else? Do they license drivers that go across state lines? I can regulate local mom and pop businesses. So on and on it goes. We'll come back to that. 14th Amendment is another place where, again, Brown v. Board. I might put that number one too. Because what that does is essentially give a broad definition to solidify what we meant by the 14th Amendment. So what does that do? Well, that lets the Constitution, continue to expand and survive. That gives the federal government new power to enforce civil rights. That guarantees civil rights. So the 14th Amendment of Brown v. Board has application in 3 different units, at least, right? it's the Constitution, it's expansion of federal power, it's civil rights. So we'll know that one as well. Okay? So done. Questions? Fantastic. Say goodbye to Kady.